Multiple outlets are reporting that AH is bankrupt. That's right, she is broke. They're saying that she has filed bankruptcy. Here's the thing though, she still owes JD $10 million. Even if she files, that's not going to change a thing. Why? Because of intent. She intentionally went out. She intentionally wanted to ruin someone's life. Little did she realize that life that she was going to wreck was going to be her own. And the mainstream, they can complain about it. Elaine, she can complain about it. AH can complain about it too. That doesn't erase the fact that she is on the hook for $10 million. You and I, we are going to talk about this today. Fun times, huh? Fun times indeed. So, hey there to all you fine folks on this fine day, by the way. I hope you are doing excellently. Isn't it amazing how things have changed for AH in such a short amount of time? We went from articles declaring her one of the highest paid actresses out there, she's a star on the rise, to articles saying she is in serious trouble. All the income from all of her movies, that's not enough to cover her debts to JD. Maybe that's why this discussion is coming up, talking about just how broke she is. She's also tried to push this in PR moves with TMZ and other outlets. And this is the media reporting it, by the way. Isn't that amazing? They're saying, hey, she's broke. She is either contemplating or filing bankruptcy, depending on the source. And they're saying, what kind of move is this? Is she trying to get out of paying JD? Here's the thing, though. It doesn't matter if the mainstream media or her lawyers or even AH scream to the wind all day long about her being broke, how they complain and they end up filing bankruptcy. This is a debt that she has to pay. JD won. She didn't think he could win. And when he did, she owes him money. And before you feel bad about that too, and that's exactly what the media wants. You can see it right here. Quote, $10 million is a truly insurmountable sum of money for most people, including celebrities like AH. Her lawyer has gone on record saying she won't be able to pay those millions of dollars, with the legal team continuing to attempt some appeals. Now, the reason that they're presenting it that way, or at least in my opinion, boils down to one word: sympathy. They want you to feel bad for her because she's the one that has to write the check this time. See, in the past, insurance companies, they picked up over $5 million, we've found out. A certain rich benefactor, we know he at least minimum wrote $6 million worth of checks propping her up. That's why she made so many delay moves. That's why they did so many things in the courtroom, because she didn't have to pick up the tab. But now she has to. The ruling is hers alone. It doesn't belong to anyone else, and she can't write that off. I mean, listen to this here. Quote, the issue is whether any money will indeed change hands. While AH has promised to appeal the underlying legal ruling in the case, she likely cannot use bankruptcy law to shield herself from having to pay JD, according to Bruce Markle. Now, this guy, he's not only a professor, by the way, he is also a former bankruptcy judge, and he brings up a very interesting statement. Listen to this right here. The analysis, it starts with a specific code of bankruptcy law. You can see it listed right there if you want to look it up. But it says that a quote-unquote discharge of debt under various other sections of the law, quote, does not discharge an individual debtor from any debt. Remember, individual debtor, that would be AH if she filed bankruptcy, for willful and malicious injury by the debtor to another entity or to the property of another entity. And remember, that's not a descriptor that's just thrown out there. JD isn't using it. You and I, we didn't throw it at her. That was what the jury itself put in its decision. Here's an example. Remember, there were 3 of these, not going over all of it, but remember, 1A was, did you find that JD has proven all the elements of defamation? Remember, when you go through this, the statement, it has a defamatory implication. It was designed by her. And then in 1B, if you answered yes to each subpart of the question, 1A, Answer the following question. Did you find that JD has proven by clear and convincing evidence that AH acted with actual malice? Again, that was found each and every time, and that's why she can't write it off. See, personally, I think that the wording in that decision that JD and his team asked for, that was a stroke of brilliance. Why? Because when it comes to laws about discharging something like this, when you're talking about bankruptcy, and again, that's what she's been screaming over and over again, I'm so broke, I can't pay this, but one word reigns supreme. Intent. This is what that professor and former bankruptcy judge has to say on that too. Quote, most tort judgments based on negligence. So you go out, you get into a car accident, say you have a slip and fall case, those things, they would be dischargeable. Indeed, this is a scary item here, by the way. Even medical and legal malpractice cases, those types of items, those would also be dischargeable. What separates AH's case from a regular tort case is the finding of intent. Again, you saw that right there in the decision. Bankruptcy law does not permit most intentional torts. So, you go out, you cost somebody intentionally, say you try to ruin their life intentionally. They don't allow that to be discharged. Defamation fits in due to the required finding of malice or intent to injure another. Now, hilariously, there is one situation where it wouldn't be as bad for her, but you know who that would be up to? It wouldn't be her. It wouldn't be the judge or any court that comes in. This would be all up to JD. See, she could, in theory, be allowed to file a certain type of bankruptcy that would allow her not to write it off. She still has to pay everything, but she could pay in installments. Now, in order to do that, she would have to ask JD for some type of setup, because were you to offer terms, you could actually have the court look at the justification for bankruptcy, and that would be much lessened. So they might say, okay. If he doesn't, though, what the court might actually see this as is her trying to stall or reduce payments. And as the person talking about this says, quote, if she has the financial wherewithal to pay the judgment, filing bankruptcy to stall or reduce payments, that could be viewed as bad faith. Oh, man. So she'd have to go in, she'd have to beg JD to make that work out. Oh, yeah, that would be something. Now, again, she could write off other things under this, and maybe that would be the plan, to focus on this. I think that would be funny, too. Again, she set out to wreck lives. She only wrecked one, though, so that would be hers. But anyway, let me know what you think about this. And as always, appreciate the heck out of you. You make this stuff work. Thank you. Can't say that enough. You want to check out the links in the description. They help out immensely, so check those out. But you being here, that is the biggest help of all. Share this around, like, comment, all of that. And thank you, too. I appreciate you. See you soon.